Chair, I'm happy to have some questions if there's time.
Senator Waters. Yep.
Thank you, Chair. Hi again, folks. I've just firstly got some questions about protecting national parks under the EPBC Act. I hope we've got the right folk at the table. As I'm sure you're well aware, almost 2 years ago at the National Press Club, the Minister committed to protecting national parks from activities such as logging, grazing, mining and large-scale land clearing. Did the department brief him on how to implement that commitment?
Senator, you'd appreciate that there are a lot of briefings with the Minister on a lot of topics, not all of which immediately spring to mind in this scenario. We'll take that question on notice. Okay. I'm almost certain that we have provided advice on that topic over the intervening period.
Okay. The Minister said that he'd intended to introduce that protection by regulation under the Act. Did the department advise him that the last opportunity to do that by regulation, given the 15-day disallowance period, was in fact yesterday?
I think the Minister's well aware of the period that the Parliament has yet left to run, Senator, for a range of reasons relating to a range of other statutory instruments. I don't believe that the department specifically advised him on that matter with regard to this regulation. Okay.
Have you briefed the Minister on options available to him to now step in and protect Queensland's national parks, in particular from logging and grazing?
Senator, we discussed this a little earlier with the senators from the other side, and the department is in the process of formulating a range of pieces of advice on those matters, both around the NRS system and the associated funding contracts, and also around the options that might exist under the EPBC Act.
Okay, excellent. I wish you speed with those advices. On the NRS, I just want to draw your attention to the website. I've got an extra copy here. One of the statements that are made on that website says all Australian governments have agreed to minimum standards that protected areas must meet to be included in and managed in the National Reserve System. I can't find any such agreement. Can you direct me to the status of that agreement?
Could I ask you to clarify what website that is? Is it the department's website or?
Yes, it is. I've got a copy here.
So it's probably a reference to the Australia's strategy for the National Reserve System, which was agreed by jurisdictions, I think in 2009, but I'll confirm that. Thank you.
It just mentions that the agreement is to facilitate certain levels of protection, and the first bullet point, which I've just handed to you there, talks about conservation forever, with effective legal means guaranteeing its perpetual conservation. I'd love to know of the existence of an agreement that delivers on that bullet point.
As I indicated in an earlier answer to Senator Birmingham, when we're looking at these matters, we look at our investment programs through the National Reserve System and funding agreements, and what avenues may be open to us through that course. We look at our environment protection and biodiversity conservation regulatory obligations, and we also look at relevant policy statements, and this is one of those relevant policy statements that all governments have agreed to. But as I indicated to Senator Birmingham before, there aren't under those policy statements typically formal compliance arrangements or levers or mechanisms for governments to hold, either the Commonwealth to hold states account or vice versa. So they are statements of intent. They're policy statements, they're policy frameworks, and statements of intent. And as I indicated, this one is still in operation, but dates I think from 2009.
Okay, so it's a statement of intent that all Australian governments have agreed to minimum standards, including designating protected areas for permanent, perpetual conservation.
Correct.
My concern is that to the casual reader, they might think that NRS properties are actually perpetually conserved, as the bullet point states. As you would know, the application by Mr Clive Palmer to mine one of those NRS properties, Bimblebox in central Queensland, is on foot and hasn't yet been concluded. I'm concerned that the statement on that website is misleading.
Certainly, Senator, it's consistent with the Commonwealth's view of our investments in properties under the National Reserve System, that when we make investments, typically in partnership with state governments, sometimes in partnership with NGOs or private sector entities, we have an expectation that those properties will move as part of the National Reserve System program to IUCN Category 1 or 2 levels of protection, which in the case of our partnership with states in those properties typically involves those properties moving to national parks under state arrangements. The properties in Queensland and frankly a range of properties across Australia are in various stages of movement from purchase, establishment of interim management arrangements, final management arrangements, and then being declared as national parks or whatever level of protection.
Great. Look, that all sounds fine, but as we've just canvassed, in Queensland, our national parks are no longer protected from logging nor grazing, and the Minister just missed the deadline yesterday to do something about that on a regulatory basis. I hope the department's busying itself with now providing some suggestions as to some other form of urgent action, given the public funds that have been provided to purchase and in some instances continue managing those NRS properties.
As we indicated earlier and Dr Dripps indicated just then, Senator, we are providing advice to the Minister on those matters.
Look, thank you. I'll move on in the very short time available to me. Just on the Biodiversity Conservation Strategy 2010 to 30, and particularly regarding the implementation plan for that document, what actions have been taken to support preparation of that implementation plan? Will that be ready as planned for the end of 2013?
I'll take the second part of your question on notice, Senator, and unless other officers at the table have a ready answer to that. There are a wide range of actions that have been taken at the Commonwealth level, certainly to underpin implementation of that strategy, including the range of investments we make under Caring for Our Country and the Biodiversity Fund, and the recent finalisation of the National Wildlife Corridors plan, which serves that.
Look, on that last plan which you've just raised, is my understanding correct that there's no legislative backing for that plan, the Wildlife Corridor plan?
There is no. I might defer to my colleague Ms Howlett at the end if you want to answer that. But my understanding is that there's no legislative backing for the plan as such, but there have been amendments made to give a role to the Land Sector Carbon and Biodiversity Board under the Clean Energy Futures legislation to provide for their advice to government on corridors.
And I'm particularly interested in whether they are going to be protected, much like the NRS properties are purported to be permanently protected, but sadly that's just a statement of intent.
That's a slightly different question. But,
Senator, as you'd be aware, under the Wildlife Corridors plan announced by the Minister late last year, there was an amendment to the Clean Energy Act which gave, well, it was not so much an amendment as a declaration by the Minister to give extra responsibilities to the Land Sector Carbon and Biodiversity Board to advise on National Wildlife Corridors matters. As that was a disallowable instrument, it needed to sit in both houses of the Parliament, and that instrument came into force towards the end of March. A process is underway at the moment to appoint that Wildlife Corridors subcommittee.
That's underway?
That
Great.
is in progress as we speak. And then that subcommittee will be tasked with developing a nomination and declaration process for wildlife corridors into the future.
And lastly, if I could just ask, how many staff are working on that National Wildlife Corridor program at the moment?
I'd have to take that on notice, Senator.
Thank you. That'd be great. I'll keep going if there's time, Chair.
Yeah, you can go another
Thank you.
few minutes. Yeah.
That's great. Look, I might go to the Queensland Regional rather the Queensland Forest Agreement, because it wasn't technically a regional forest agreement. I'm not too sure if this is the right section to ask my questions, but I'll give it a go. I'm just wanting to confirm that given that the South East Queensland Forest Agreement is now no more, Queensland Premier rescinded that agreement, that the exemption for that particular area under the EPBC Act no longer applies. That's my legal interpretation. So my question is whether the department is taking any steps to advise either the Queensland Government or the logging operators who are now permitted and have in fact applied for permits, advise them of their obligations under the EPBC Act and that they may need to refer or they could potentially face prosecutions.
Senator, yes, we're aware of the actions of the Queensland Government that you were talking about, and we have been providing some advice to our Minister, and in consultation with our agriculture, fisheries and forestry colleagues, they are also providing advice to Minister Ludwig. And Ministers Ludwig and Burke have written to the Queensland Government alerting them to their statutory responsibilities under Commonwealth law.
Great. And also to the logging companies themselves, is there any sort of outreach so that people don't inadvertently break the law?
That would be the responsibility of the Queensland Government, Senator.
To advise about federal environment law?
Well, not to advise about federal environment law, but to advise the industry about the changes in the regulatory environment in Queensland.
Okay, look, I think I've asked my key questions.